Okay, it's 1 o'clock, so we'll begin. Thank you for attending Hunt & Hunt Victoria's Workplace Relations webinar on closing loophole reforms. My name is Richard Scougal and I'll be presenting today together with David Thompson. I acknowledge that I'm hosting this webinar from Naarm in the lands of the Wurundjeri people. I acknowledge the traditional custodians of the various lands on which you all work today. I pay my respect to their elders past and present. Today, I'll start by talking about the developments over the past year or so that led up to the closing loopholes changes. I'll then concentrate on part one of the closing loopholes changes that were enacted in late 2023. David and I will outline these changes and what they mean for business leaders and HR professionals. David will look at how some of these changes interact with state laws, which cover the same ground and impact on compliance obligations. I'll then look at part two closing loopholes, which passed the Senate last Thursday and then passed the House of Representatives to become law on Monday this week. There have been some significant changes in Australian workplace relations laws in the past few years as a result of new legislation, decisions in the courts, and changes to modern awards in the Fair Work Commission. In March 2023, there was a court case that made it clear that employers cannot require employees to work on public holidays. Then in May, the rules in modern awards about holiday shutdowns changed and set a prescribed period of notice that must be given before annual shutdowns and clarified that employers cannot require staff to take leave without pay if they don't have enough annual leave to cover the closure. Then from 6 June 2023, the right to request flexible working arrangements was extended to pregnant workers and workers dealing with domestic and family violence. New obligations on employers were introduced, requiring them to engage with workers about flexibility requests, to explore compromises, and to give more information about the reasons why they decided to reject the request if that's the case. Employees won the right to apply to the Fair Work Commission to settle disputes if they weren't satisfied with their employer's response. From 1 July 2023, there were changes to the paid parental leave entitlements to increase this to 20 weeks. The amount of paid parental leave will increase again to 26 weeks between July 2024 and July 2026. From 6 December 2023, there are now new limits on the use of fixed-term contracts, which can't extend for a period of more than 2 years, including renewals and extensions. There are some key exceptions to look out for here. Then in September 2023, the federal government passed their closing loopholes, introduced their closing loopholes changes to Parliament. The Senate opted to split this bill into two, and the less controversial of the changes were passed as Part 1 in December of 2023. Part 2 passed on Monday, as we've discovered. The amendments enacted in Part 1 are as follows. The small business redundancy exemption. New powers for the Fair Work Commission to make same job, same pay orders to apply to labour hire workers. Additional rights and protections for workplace delegates. Strengthening protections from discrimination for employees suffering from family and domestic violence. An introduction of new Commonwealth offences relating to industrial manslaughter and wage theft, and some additional Commonwealth WHS and work cover reforms. The Part 2 closing loophole changes are the headline grabbing right to disconnect, a new definition in the Fair Work Act for casual employment, and definitions for employees and employers based on the multifactorial test. Minimum conditions, collective bargaining, and unlawful termination laws for gig workers and road transport contractors, and broader rights for independent contractors to challenge the terms of their contracts. There were also increased penalties for sham contracting and a tightening of the defence in relation to that. Looking first at the small business redundancy exemptions. This change addresses an anomaly that caused some employees of employers who were bankrupt or in liquidation to miss out on the NES entitlement to redundancy pay, which would otherwise have been paid to them on dismissal. Now, the general rule is that small businesses, that is, businesses with less than 15 employees, don't have to pay redundancy pay. And this is still the case. However, there was an unintended loophole or an anomaly that existed where the business was being wound up and where that business had appointed a liquidator who let go of the entire workforce. If they kept one or two staff on to help tidy things up and turn off the lights, then those employees would miss out on redundancy when they were also eventually made redundant. So these new changes mean that employees who stick around to help liquidators close up shop will still get their redundancy entitlements. There are also now some changes to the same job, same pay rules. This is a new power for the Fair Work Commission to make orders requiring labour hire suppliers to pay their employees the same rates of pay as employees at the host employer when they perform the same kind of work. The changes allow employees, unions, and host employers to apply to the Commission for an order that labour hire employees must be paid at least what they would have received under the host's enterprise agreement. This is a response to criticism that labour hire was being used to undercut wages. In industries such as mining, construction, stevedoring, agriculture, transport, employers could negotiate wage rates with unions into enterprise agreements, but those agreements would not apply to labour hire workers at that host employer, at the host business. So labour hire workers could be paid less when compared to employees covered by an enterprise agreement to do exactly the same work. Many large corporates, including BHP, Qantas, Cube, and CIMIC, had even established their own internal labour hire subsidiaries to supply labour hire to other companies within the corporate group. The ACTU and others argued that this created a loophole that avoided paying workers negotiated wage rates and entitlements such as leave. The ACTU said 600,000 workers were employed, or about 4.5% of the workforce, as labour hire workers, and they earned, on average, $5,000 less than employees that were engaged directly by the host. The Labor government said that the changes would impact on these changes would impact about 67,000 workers, that is, labour hire workers at job sites where the host has an enterprise agreement in place. The way the new laws work is that an employee or the union or the host for that matter can apply to the Fair Work Commission for what is called regulated labour hire arrangement orders, which will compel labour hire employers to pay the same protected rate of pay to employees engaged to pay the same protected rate of pay as employees engaged directly by the host. These changes commenced on 15 December 2023. However, the orders cannot come into force until 1 November 2024. That means that we'll soon see the first test cases in this area and decisions in the Commission. However, those decisions won't apply until the 1st of November. The rules apply whether or not the host and the employer are related bodies, corporate or not. So labour hire employers can also request payroll information from the host, and the host will be compelled to provide wages information if it is needed to calculate the correct rate of pay. There are some conditions and exemptions that apply to the same job, same pay orders. The Commission must not make such an order unless it is satisfied that the work being performed is not the provision of a service rather than the supply of labour. We'll look a bit later at what this means. The Commission must not make an order if it would not be fair and reasonable in the circumstances. Orders cannot be made where the host is a small business that is employing less than 15 employees, and they cannot apply where the work is being done under a training arrangement or if it's necessary to engage staff for less than 3 months, for example, if there's surge work or to fill a short-term replacement. That 3-month exemption period can be shortened or lengthened on application to the Commission. Matters that must be considered in relation to the provision of a service. And this is one of the first tests in these amendments that look at the difference between employees and contractors. Matters that must be taken into consideration in relation to the provision of services include the involvement in the employer in matters relating to the performance of work, and the extent to which in practice the employer directs, supervises or controls the employees. As we said, there's also an exemption here where the Fair Work Commission must not make orders if it would not be fair and reasonable in the circumstances to make those changes. So some factors to consider here are pay arrangements, the nature and scope of the host's enterprise agreement, the history of agreements that apply to the host and the employer, the relationship between the host and the employer, and whether or not the host is part of a joint venture or a common enterprise. Next, we'll look at workplace delegates' rights. In clear support of their union backers, the Labor government has strengthened protections for freedom of association and the exercise of workplace delegates' rights. Delegates are direct employees within the business who have been chosen to represent their union and champion workers' industrial rights. From 15 December 2023, employers must allow delegates to communicate with other employees and whether they're current or prospective union members in relation to their industrial interests. The Act gives delegates the right to represent those employees, the right to access facilities to conduct their union duties, and also, unless it's a small business, delegates will get reasonable access to paid time off in order to receive training in relation to their delegates' duties. What is reasonable in these circumstances will depend on the size and the nature of the enterprise. From 1 July 2024, modern awards will incorporate these delegates' rights, and enterprise agreements from then on must also include these rights. Currently, under state and territory work health and safety laws, health and safety representatives may request assistance from somebody else to perform their role in the workplace. Employers must allow these assistants access to the workplace in order to perform these duties. However, if the HSR assistant is a union official, they must hold an entry permit under the Fair Work Act. There's now changes to the Fair Work Act so that this requirement disappears. Union officials can now enter a workplace to assist HSRs without the requirement to hold a permit to do so. There are also rules here about what officials entering the site can and can't do while they're there and how employers must treat them. For example, officials entering to assist HSRs cannot use or disclose information that they obtain in that role for any unauthorised purposes. Employers must not refuse or delay access for officials in this capacity, and they must not hinder officials who try to assist HSRs. So employers should make sure that their leadership teams are aware of these new delegates and officials' rights and how they will handle them when requests come from the unions. They must be ready to do so confidently and know what is allowed and where they can draw the line, particularly when it comes to reasonable time off and the right of entry. So now I'll hand over to David to look at some additional Part 1 changes, and then I'll jump on to give you an initial overview of the Part 2 amendments. Thanks, David.
Hello there. Sorry, just playing with the technology there for a second. You can hear me all right, Richard, can you? Yep, good. Okay, perfect. So I'll be talking primarily about the new wage theft provisions, which have received a lot of publicity, but also briefly about further protections against discrimination and the new Commonwealth industrial manslaughter offence. So just back one slide from that, Richard. I think we've got one. Strengthening protections against discrimination. In addition to the Respect at Work amendments that the Commonwealth introduced in recent times that covered off on a few discrimination issues, the Closing Loopholes legislation has now introduced one further protection against discrimination, and that involves adding an attribute, and the attribute is family and domestic violence, to the list of attributes in the Act pursuant to which adverse action is unlawful. And you may recall that the list of attributes includes someone's gender, sexual preference, race, religion, etc. Now it includes family and domestic violence. So it's is now unlawful for employers to take adverse action against an employee or a potential employee because they have been or are being subjected to family and domestic violence. Now, this is designed to protect workers who may be performing poorly because they're victims of such violence, or they may not be able to attend work for a period again because they're a victim of such violence. In addition to that, there's also been included a prohibition on employers and the Fair Work Commission, including terms in enterprise agreements and modern awards that discriminate against a person on the basis of subjection to family and domestic violence. So, for example, if you have an enterprise agreement, you have a common garden variety term about abandonment of employment, which says that if you don't turn up at work for at least 3 days and you don't communicate with us during that period, then you're deemed to have abandoned your employment. Then that would offend against these provisions if the person is absent because of being a victim of family and domestic violence. And these changes commenced from 15 December last year, shortly after the legislation was voted up. Next, thanks, Richard. So I move on now to wage theft, which is primarily what I'm talking about today. Wage theft has been used as an emotional term in parliamentary debates and media releases on the legislation. The issue is really what falls within the term wage theft. Technically, and this is a problem, if you are not directly paying award entitlements to your employees for allowances or overtime, but you are paying way over minimum hourly rates. So, for example, your employee is being paid 3 times their minimum award entitlements to minimum wages plus allowances and overtime. So they're doing very well, but if you don't have a valid set-off clause in your employment contract, you could still be guilty of wage theft. Now, that can be contrasted with the situation where you do have a valid set-off clause in your employment contract. There is no wage theft. Morally, there's no real difference between the two, but legally there is. And that's why you need to ensure your contracts are in good shape. So here, there's now a new offence under the Fair Work Act, a criminal offence. And as you may be aware, there's already been a civil offence there for many years since the Act first commenced in 2008. And so the Fair Work Ombudsman has been able to prosecute for civil offences for underpayment since then. This new offence applies to employers who intentionally engage in underpayments of employees, and the provisions will commence operation on 1 January next year, or such later date as a day after the Voluntary Small Business Wage Compliance Code is declared. However, the federal government is likely to pull out all stops to declare that code this year, so the likely date is still 1 January next year. Significantly for your purposes, and this is good news, these provisions apply to underpayments that occur after the offence commences, so they're not retrospective in their application. Next, thanks, Richard. So what underpayments does wage theft apply to? There are 3 categories of underpayments that it covers. Firstly, entitlements of employees have under the Fair Work Act. So under the National Employment Standards, employees have entitlements to receive paid annual leave, redundancy pay, notice of termination, or maybe pay in lieu if your contract allows that on termination. If those are underpaid, then you can be prosecuted for wage theft. Similarly, the provisions cover entitlements under an award or an enterprise agreement, which are both described as, or both part of the term Fair Work Instrument. So that covers entitlements to wages, allowances, overtime and penalties for working after hours or at weekends. And thirdly, the legislation covers underpayments relating to a Fair Work Commission order. So if you dismiss one of your employees and the Commission orders reinstatement with back pay, if you underpay the back pay, then you can be prosecuted for wage theft. There's one significant issue there, just back on that last slide. It does not include, this legislation, entitlements under employment contracts. And that's a very significant exclusion because it means the laws do not cover entitlements to remuneration under contracts over and above minimum award entitlements to rates of pay, to perhaps an annual bonus you had in your contract, or payment of home office expenses. In that situation, if you're underpaid, the remedy remains the traditional one of a breach of contract claim in a court, except for currently perhaps in Victoria and Queensland, which I'll get onto in a few minutes. So what are the elements of the wage theft offence? And sorry, I use the abbreviation WT for wage theft. There are three elements. Firstly, the physical one, the fact of the relevant underpayment being made. Secondly, the employer engages in conduct, and that can be an act, but also an omission. So a failure to do something is relevant as part of the conduct. And thirdly, the requirement is the conduct leads to an intentional failure to pay the required amount to the employee, and that's payment in full on or before the day it's due. So timing of the payment's also relevant. If you pay it late, you can technically be prosecuted for wage theft. If you pay it 1 week or 2 weeks late, that's not going to happen. But if you significantly delay it, it's a possibility. However, intention is the critical issue. So next, thanks, Richard. Proving intention for wage theft. What is it necessary for the prosecution to do? The good news is the offence does not apply to underpayments that are accidental, inadvertent, or based on genuine mistake. And many employers mistakenly do not pay some entitlements under awards to employees because awards are not very clear in their wording. They're usually grey rather than black and white, and it can be difficult to work out whether there is an entitlement or not. What is necessary is the prosecution must prove beyond reasonable doubt, and that's the criminal standard of proof, beyond reasonable doubt, that the employer intentionally engaged in the conduct and intended that this would lead to a failure to pay the monies owing to an employee. And that is an extremely difficult thing to do. It can be compared with the civil standard of proof, which is the balance of probabilities, which is much easier to satisfy. So how can this criminal standard of proof be satisfied here? Well, potentially when the prosecution's obtaining information, doing their investigations, they may obtain an email history. If you've got someone in your payroll department who's advising a manager that this entitlement must be paid or should be paid to the employee, they should be receiving it, and the manager sends an email reply saying, no, there's no way we'll be paying it, don't do it, then that can be used as evidence of an intentional underpayment. Or similarly, evidence can be obtained by the prosecution from employees or former employees about what a manager told them. And they will usually be people in payroll, or if you have an outsourced payroll, the people who provide the outsourced payroll with information, they'll give evidence about what their managers told them not to do. There are potential defences to such a prosecution on the basis that you made a mistake or there was an absence of knowledge in proving the required intention. So if you're able to satisfy a court that you didn't have a guilty mind, then you may not be successfully prosecuted. So previous slide, Richard, there's one more point there. In relation to proving intention for wage theft, there are two additional issues that are relevant. Firstly, the conduct of officers or employees can be imputed to the business. And officers is not just board members and directors, it can be managers. So if managers' employees act within the actual or apparent scope of their employment or authority, if they engage in intentional conduct, then that intentional conduct can be expressly or impliedly found by a court to be intentional conduct of the business. In addition to that, the legislation also says that a failure to create and maintain a corporate culture of compliance relating to entitlements can help prove intention. So this allows a court to go one step further If there's evidence of deliberate sloppiness about complying with employee entitlements, that may be enough to prove intention for wage theft. So if there's a culture that directed, encouraged, tolerated, or led to the non-compliance, that may be enough in some cases. Okay, penalties. And this is really significant. We have eye-watering penalties, maximum penalties that have been introduced here for wage theft. For individuals, the maximum is just over $1.5 million or up to 10 years imprisonment. And for employers, it's the greater of 3 times the amount of the underpayment if a court can determine that. And often that's not possible because the employer's records are poor, or $7.8 million as a maximum fine. And that's extraordinary. And you compare that with the current maximums for the civil prosecutions under the Act for underpayments. For individuals, that's about $19,000 per offence. And for businesses, a maximum of $188K per offence. So they're very, very different. The good news is that course of conduct reductions apply, and that's the same as the situation that already exists for civil prosecutions. And what that means is if your business underpays 20 employees for the same entitlement, such as overtime, the offences can be said to arise out of the same course of conduct by the employer and therefore should be one offence. And whilst the prosecution will still charge you with 20 offences, a court is likely to be persuaded to treat them as one offence. Or if you're plea bargaining with the prosecution, you might be able to persuade them to roll the 20 offences up into one offence for the same reason, because they know the court will do that anyway. Okay, are there any ways to avoid wage theft prosecutions? Well, the Minister, Tony Burke, in his second reading speech tried to give some comfort to employers by suggesting there were, and he outlined 2 options, but these are very limited. Firstly, if you self-disclose conduct, that may mean the Fair Work Ombudsman may decide to enter into a cooperation agreement instead of referring the matter off for a prosecution. However, this cooperation agreement option only applies where you've self-reported a possible commission of an offence. Now, of course, employers are unlikely to be reporting that they deliberately committed an underpayment, but at least they could report the fact of having made an underpayment. And self-reporting has also always been relevant to whether the Fair Work Ombudsman issues civil penalty proceedings under the legislation anyway. The second ground you can avoid prosecution is if you're a small business, and that means a business that employs less than 15 people. And I don't think there are many attendees here today in that category, but if you're in that category, and you have complied with the Small Business Wage Compliance Code, then you can avoid prosecution. That code hasn't been released yet and will be later in the year, but it'll be roughly comparable to the Small Business Unfair Dismissal Compliance Code, which has more simple steps that small businesses are expected to follow rather than more complicated requirements that are put on larger organisations. The other relevant factor in relation to these prosecutions is they may only be issued by the Commonwealth DPP, the Director of Public Prosecutions, or the Australian Federal Police. The Fair Work Ombudsman must refer these matters off for those prosecutions, whereas by contrast, the civil prosecutions, the Fair Work Ombudsman has and still will be able to issue those prosecutions under the Act. Okay, now the cooperation agreement safe harbour option, if you self-report that I just mentioned, in deciding whether to enter into a cooperation agreement, the Act says the Fair Work Ombudsman must have regard to a number of factors. And by the way, these factors on the slide are all factors that the Federal Court determined in case law going back between 2008 and 2012. The Federal Court put these in place in relation to the amount of penalty it might impose on employers where there was a civil underpayments prosecution issued. And we were on the Fair Work Ombudsman panel at the time, and we had to put together submissions to the court on these sorts of issues relating to how much an employer should be fined. So in this case, these requirements have been enshrined in legislation in relation to cooperation agreements. So the Ombudsman must have consideration to whether the employer's provided voluntary, frank and complete disclosure of the conduct, and that includes the nature and level of the disclosure, how comprehensive it is. It must consider cooperation with the Ombudsman concerning the conduct. Thirdly, the Ombudsman must assess your commitment to continued cooperation, and that includes providing the Ombudsman with comprehensive information to enable the effectiveness of your actions and approach to remedying the conduct to be taken into account. So it's not only initially you disclose very well and frankly, you have to keep the Ombudsman informed as to what you're doing to ensure you're not going to fall foul of underpayments requirements in the future. Fourthly, the Ombudsman needs to consider the nature and gravity of the conduct. Fifthly, the circumstances in which the conduct occurred. And lastly, your history of compliance with the Act. So if you've been a previous offender against the Act, it's not going to allow you to enter into a cooperation agreement. Now, we do already have existing state wage theft laws in 2 states, in Victoria and Queensland. Both of these were introduced in 2020 by the Victorian Wage Theft Act 2020, and in Queensland, amendments to its criminal code. There are some differences to the new Commonwealth wage theft laws, which are worth being aware of. Firstly, the Victorian Act applies to more than intentional conduct. It also covers recklessness. Now, it's possible that the corporate culture provisions I talked about before in the Commonwealth Act may cover some reckless conduct, but we need to await some case decisions on that. The second significant difference between the Commonwealth wage theft and Victoria and Queensland is that Victoria and Queensland are much wider. In addition to covering entitlements under the Fair Work Act and awards, enterprise agreements, etc., those state laws also cover entitlements to any wages payable under an employment contract, for general wages and other entitlements. So it is much, much wider. And in Victoria, the government established 3 years ago the Wage Inspectorate Victoria to deal with these offences. You might be interested to know that to date in Victoria, over the last 3 years, there has not been one successful prosecution of an employer for wage theft. There have been a number of cases issued. There was one case that got to the High Court late last year, but the Wage Inspectorate withdrew that. And that primarily demonstrates how incredibly difficult it is for a regulator to prove intention on the criminal standard beyond reasonable doubt. The other relevant factor is because we're a federal system of government, we have a constitution, and we have section 109 of our wonderful constitution, which says that when a state law is inconsistent with the Commonwealth law will prevail and the state law is invalid to the extent of the inconsistency. Now, what this means is that a lot of the Victorian Act and some of the Queensland Act will become invalid from 1 January next year when the Commonwealth Act comes into force. This has, as a result, the Victorian government waved the white flag last December, and as at 14 December, a week after the Commonwealth legislation was voted up, it announced on its Wage Inspectorate Victoria website that it will be repealing all of its wage theft provisions. This may happen in Queensland too. I'm not sure what's happening there at the moment. So, in conclusion on this issue, if you're preparing for this new wage theft laws, and I recommend you do, if you haven't done this already, it's a really good idea to audit very closely your remuneration payments to employees, to check your employment contracts, check the entitlements of your employees under awards and enterprise agreements, just to make sure they may not be entitled to things. They may not be entitled to things that you're not paying them, and seek advice if necessary. Okay, now I'll just deal very briefly now with the next topic, industrial manslaughter. The reason it's only brief, but the Commonwealth, in Closing Loopholes, has amended its own Work Health and Safety Act to introduce, excuse me, the new offence of industrial manslaughter. This commences in a few months on 1 July. However, its coverage is very limited, and Commonwealth departments and agencies and some federal public authorities are not covered. So it's not directly relevant for attendees today, but there is indirect relevance I'll come onto in the next slide. So the offence of industrial manslaughter, IM, is established here, as in most of the other state and territory legislation, if four things are satisfied. Firstly, the conduct is intentional. Secondly, it breaches a duty, that's a duty of care. Thirdly, it causes death. And fourthly, the person, and a person can be the organisation or it can be an individual, the person is reckless and or negligent as to whether the conduct would cause death. So in relation to the relevance of this, next slide, please, Richard. Firstly, we have mirror workplace health and safety acts and regulations in the Commonwealth and every state and territory except Victoria, but the Victorian provisions are broadly similar too. And in recent years, there's been a lot of cooperation and consultation about health and safety around the country between the different bodies and governments. So secondly, the politics behind industrial manslaughter makes these changes relevant because they reflect a strongly increased, relatively recent national focus on these provisions to minimise workplace deaths and to use increased penalties as a means of deterrence. And there's existing state and territory industrial manslaughter legislation as outlined in that slide. The ACT introduced it some years ago, 20 years ago in 2004, but otherwise more recently, Queensland in 2017, Victoria and the Territory in 2020, WA in 2022, and New South Wales has it on the drawing board for later this year. So the requirements of the Commonwealth industrial manslaughter offence cover off on what other states and territories, except New South Wales and Tasmania, have done already. The Victorian provisions have some differences, but I won't go into those today. And finally, there's just one other amendment I'll briefly mention to further Commonwealth health and safety legislation, and that is the Commonwealth Asbestos Safety Eradication Agency Act has been amended so it not only covers asbestos and asbestos-related diseases, but now also covers, or the agency's functions cover silica and silica-related diseases such as silicosis, emphysema, and lung cancer. The driver for this is that it was diseases caused by exposure to engineered stone bench tops in people's kitchens. And you may have seen all the publicity about that, and slowly but surely these bench tops will be outlawed in all jurisdictions around the country in the future. So that's it from me. I'll hand over to Richard back on Loopholes 2.
Great, thanks David. So as we know, Loopholes 2 became law this year, this week, on Monday this week, after it passed the Senate on Thursday and then was rushed through on Monday. IR Minister Tony Burke has summarised the reforms by saying they will end the concept of forced permanent casual by providing the proper pathway for casuals seeking to convert to more secure permanent work and simplify the process for employers. Part 2 will also introduce world-leading minimum standards for gig economy workers, such as rideshare drivers and delivery riders. They will ensure a safe and sustainable and viable trucking industry, including for owner drivers, and the reforms will stop unpaid overtime for workers through the right to disconnect from unreasonable contact out of hours. Now, looking first at the idea of casual employment and the definition there, the changes amend the definition of casual employee in the Fair Work Act to create a test that takes consideration of the totality of the employment relationship. The casual conversion rules in the Fair Work have also been overhauled. There is a new employee choice framework that enables casual employees to notify their employers that they wish to become permanent full-time or part-time employees. The outgoing definition of casual employees was introduced in 2021, and it said that a person is a casual if they accept an offer for a job where there is no firm advance commitment to continuing an indefinite work according to an agreed pattern of work. According to the new definition, An employee will be a casual employee if both of the following conditions are met. The employment relationship is characterised by an absence of a firm commitment, so firm advance commitment to continuing and indefinite work, and the employee is paid a casual loading or a specific rate of pay to casual employees. Now, this shifts the focus away from what was agreed at the time that the contract was entered into and back to the overall nature of the relationship. The Act will apply indicia to assess whether an employment relationship is characterised by an absence of a firm advance commitment to continuing and indefinite work. So you'll be able to look at things like whether there was an inability of the employer to elect to offer work and an inability of the employee to elect to accept or reject the work, whether it is reasonably likely that continuing work of the kind performed by the employee will be available in the future, and whether there are full-time or part-time employees performing the same kind of work in the enterprise. If the employee engages in a regular pattern of work, you look at the pattern of work and whether it will be regular, and whether it doesn't need to be completely uniform, and there can be some fluctuations or variations over time, but you look at the pattern of work. The casual conversion regime now gives employees more rights about their casual employment and the right to convert. Casuals can notify employers that they wish to change their status to full-time or part-time after 6 months of employment, or 12 months if it's a small business. Even after that, unless the issue has been raised formally in the last 6 months, employers will have an ongoing right to make notifications they wish to convert to permanency. They can do this if they believe that they no longer meet the definition of casual under the Act. So employers must respond within 21 days, and there are grounds on which an employer may not accept the notification, and this includes that the employee still meets the new definition of casual employee, and accepting notification would be impractical. So the take-home message here is that employees have a new right after 6 months to request conversion to permanency. This sits alongside the existing requirements for employers to consider casual conversion after 12 months. So those rules still apply, the casual conversion rules, they still apply, except that under the old casual conversion rules, employees had the right to request conversion. Those have disappeared, and these new rights that we've just outlined exist after 6 months. So this is fairly confusing here. You have two different kinds of regimes that deal with casual conversion, and employers will need to get across both of them and understand what their obligations are when they're responding to employee requests, but also what their own obligations are when they have to look at the issue themselves and consider offering permanent conversion. So this is clunky and confusing, and no doubt will lead to disputes in the Commission. Now, if I was Taylor Swift, I'd leave this one for my encore. This is the right to disconnect, the one that's grabbing all the headlines. Now, the decision to include the right to disconnect has been compared to a dance of the sugar plum fairies. Business leaders have complained that they were not consulted at all about this change, which came into effect only 24 hours, or which was introduced only 24 hours before the bill was passed. The new right allows employees to refuse to monitor, read, or respond to contact or attempted contact by their employer or a third party such as customers or suppliers outside of the employee's working hours unless the refusal is unreasonable. So they have the right not to engage with employers' emails or telephone calls unless that refusal would be unreasonable. The law comes into effect in 6 months' time or later for small employers. And I've seen some commentary to say that for small employers, it'll be in 12 months' time, and others say it's in 18 months' time. It's so fresh, I still haven't got to the bottom of that question yet, but small employers don't need to comply for at least 12 months. As originally proposed, the law would have prohibited employers from contacting their staff out of hours, and they would risk significant fines if they did so. Instead, this has been framed as a right for employees not to respond to contact from employers. And the Fair Work Commission has new powers here to deal with disputes. So if an employee believes that the employer is making unreasonable contact with them outside of work hours, they can apply to the Fair Work Commission for stop orders to stop employers from forcing them to engage with the calls and the emails. Likewise, the Fair Work Commission can also make orders to stop employees from refusing contact. So really it comes down to what is reasonable in the circumstances. And if the Fair Work Commission makes an order, whether it's against an employer or an employee, if it's breached, there could be civil penalties. There are a list of factors here to consider in terms of what is reasonable after hour contact. And we can look at the reasons why the contact or attempted contact have been made, how the contact or attempted contact has been made by the employer, and the level of disruption the contact causes to the employee, the extent to which the employee is compensated to remain available to perform work after hours or to do additional work. The nature of the employee's role and the employee's level of responsibility will be relevant, and the employee's personal circumstances, including family and caring responsibilities, will be relevant. So you can have two employees doing essentially the same work, being paid the same amount, but if one is on or one has carer responsibilities for a school-aged child, it may be reasonable for them to ignore, Slack pings, but the other person must look at them. So modern awards will be amended to include this right to disconnect, and these constitute workplace rights for the purposes of general protections provisions in the Fair Work Act. I'll also now look at this idea of independent contractors and their rights. The changes in Part 2 introduce greater workplace protections for independent contractors in the gig economy, in the trucking industry, and also more generally. They include minimum standards and protections for gig workers. Now, this is a huge shift in the law. The Fair Work Commission has been given powers to set minimum standard orders for employee-like workers. Here, employee-like workers mean workers who perform digital platform work, but who are also either they have lower bargaining power, or perhaps they receive comparatively low pay, or they have low authority over the performance of the work. They must meet two of these three criteria. It is not intended that the minimum standard orders apply to skilled tradespersons or contractors just because they might look for work on digital platforms like Airtasker or HighPages. You still need to meet two of those three criteria, i.e. there needs to be some vulnerability and gig economy style workers are the only ones that will be caught by these minimum standard orders. Now, this is obviously an area of contention, and who is and isn't covered by these orders is yet to be determined by the decisions in the Commission. The Commission will be able to make minimum standard orders which relate to payments, deductions, insurance, record keeping, but they cannot make orders if they relate to overtime rates, rostering, and penalty rates. So the scope of the Commission's powers here has been calibrated to lift workers' conditions while also maintaining a level of flexibility in the way that digital platforms works. So gig workers do not become employees, they are employee-like workers. So they have some rights, but not others. They don't get overtime, etc. So Uber Eats Managing Director Beck Niss has told the Financial Review this week that the Act now regulates gig workers as independent contractors working flexibly. And Uber Eats thinks this is a real step forward, which will allow for a sustainable industry. She then goes on to say, but I will say, until we see the exact content of the Fair Work Commission's minimum standard orders, yes to be seen what the impact of these orders will be. Employee-like workers, gig workers, will have the right, have unfair deactivation rights, similar to unfair dismissal protections. They'll also be able to enter into collective agreements. So employers, digital platforms, can enter into collective agreements with organisations representing regulated workers. There's going to be a range of changes here that are very similar and apply to road transport workers. So road transport industry workers will have road transport minimum standard orders, which are very similar. They'll also be able to challenge the termination of their contracts through unfair termination claims, similar to the unfair deactivation claims that gig workers can bring. And again, the Act allows for road transport collective agreements for road transport contractors. So as well as those gig workers and transport workers, general independent contractors have new rights under the Fair Work Act. They can bring a challenge against their contracts if they believe they are unfair. And the Commission can make orders to set aside, vary or amend service contracts which are unfair if the terms relate to workplace relations matters, that is, things that are similar to an employment relationship, such as remuneration, allowances, leave entitlements, and work of pay, hours of work. Then looking at the definitions of employees and employers. There are new definitions in the Fair Work Act for employee and employer. This is the latest development in the evergreen debate about what is an employee and what is a contractor. Whether someone is an employee or employer needs to be determined now by looking at the real substance, the practical reality, and the true nature of their contract and the working relationship, I should say, between them and their employer. So the totality of the relationship is relevant, not just the contract that was entered into between the parties. And this has been a change in direct response to the High Court decisions in 2022, personnel, contracting and JAMSEC, where the court emphasised the importance of the contractual terms when characterising the relationship. So this is an interesting development here because now we have a common law contract that's been reintroduced, but has in a sense been introduced into the statute for the purposes of the Fair Work Act. So we have this new definition within the Fair Work Act that applies for the Fair Work Act, and it overrides the High Court decision. But the High Court decision about what is an employee still applies in common law and still applies for other statutes that relate to this area. So when you think about work cover, superannuation, tax, all of those different pieces of legislation, if they look to what an employee is, they look at the common law, which applies the High Court case. So we have a very confusing matrix of definitions here that applies depending on the context in which you're trying to identify whether a person is an employee or not. So just quickly then, there are some other changes as well that I won't go into in detail, but I'll just flag in part 2. There is a new defence against sham contracting, which is tighter and makes it harder for employers to argue that they genuinely believe an employee is a contractor. Part 2 also saw the introduction of the union right to obtain permits to, they get an exemption from having to give 24 hours notice to enter a workplace to investigate underpayments. As David's mentioned, there's some changes to deal with silica safety. There's also a presumption in relation to PTSD for federally employed firefighters and other first responders. There's been some changes to the single enterprise agreement rules to extend to franchisees. And there's also been changes to the intractable bargaining declarations, so that declarations must be no less favourable to an employee than the prior enterprise agreement that they looked at. So that's our first sort of pass at the part 2 provisions. I will say that they're interesting from an academic point of view because you can see that what the government's doing here is expanding the reach of the Fair Work Act to different kinds of workers outside of the traditional employment relationship. So you've got gig workers, casuals, contractors, sole traders, very small businesses, I'm thinking trucking contractors, that all now have protections and rights under the Fair Work Act where they didn't exist before. So this is an attempt by the Labor government to bring the Fair Work Commission into the 21st century or modern times and to identify or address and encompass the different ways that workers are now engaged in our society. We'll be looking at this more in weeks to come. We're organising a joint presentation with our Sydney colleagues, and there'll be some details shortly about the dates for a further look at the part 2 changes. So that's all I had to say about that now. We've got about 6 minutes. If there are any questions, you can put them in the chat function. I'll just wait a few minutes to see if anything pops up there before we sign off. There is obviously one question there about whether the slides will be available, and yes, they will be. We'll also circulate a copy of the presentation, the recording. Are there any questions about the substantial matters? No, well, if there are, feel free to contact either David or myself. And certainly, if there are any questions coming up about part two, let us know and we'll consider them when we give our next presentation in a few weeks' time that'll more squarely look at the part two changes. So I might leave it there and thank everybody for your attention today. Good afternoon.